appeal in the matter of BDW Trading Ltd and AECOM Infrastructure and Environment Limited and others, part heard.
Yes, Mr. Holbrook.
Good morning, my lords, my lady. I propose to start with the appeal arising from the application to disallow the amendments.
Yeah.
My submissions in relation to this part of the appeal fall into 5 sections. 1, what is the correct test? 2, how is the test applied? 3, was BDW's claim constrained? 4, why is the appellant incorrect? 5, to demonstrate the judge was correct. So then, what is the correct test? May I invite the court to turn, please, to section 35 of the Limitation Act. This is in your authorities bundle behind divider 3.
Yeah.
In subsection 1, there is a deeming provision in relation to new claims. In subsection 2, there is an explanation of what is meant by a new claim, and of course, a new cause of action or a new party is a new claim. And then the rule that we're interested in is 35.3. Except as provided by section 33 of this Act or by rules of court, neither the High Court nor County Court shall allow a new claim within subsection 1b above, ... to be made in the course of any action after the expiry of any time limit under this Act, which would affect a new action to enforce that claim. The rationale for that rule is well known, but it is a limited rationale. The rationale is simply so as to prevent a defendant losing the advantage of a limitation defence. It will be our submission in a few moments that if BDW is entitled to constrain its claim, and did constrain its claim, so that it could prejudice no limitation defence, then the appeal must be dismissed. Now, if we can put the Limitation Act to one side for a moment and just quickly remind ourselves of Rule 17.4, this is in the 21 White Book at page 684. And it says, this rule applies where a party intends to amend his statement, applies to amend his statement of case in one of the ways mentioned in the rule, and a period of limitation has expired under the Limitation Act 1980. So the language there is a little bit different from the language of section 35.3 of the Limitation Act, but nothing turns on that. And so far, the test is this: whether the new claim advanced by amendment is made after expiry of a limitation period. But it would be wrong to think that that is the start and the end of the test. It is not. Because what one next needs to do is to look at the limitation period which is in question and which is provided for by the statute. And before going directly to section 14b, I will, if I may, take a little bit of a run-up. There are many limitation periods provided for by the Limitation Act. May we start, it's not in the bundle, but it is in volume 2 of the White Book. And if my lords or my lady don't have that, I've copied the section. But may we turn to section 2 of the Limitation Act. Which is at page 2430 of the 21 White Book. And for anyone in an earlier White Book,
I'm in an earlier white book, but I shall find my way. So section 2 is what you want us to go
I have a 2021 which nobody appears to have opened yet. It's still got the cellophane wrapping. Could you say the page number again,
Yes, of
please?
course. It's 2430.
Thank you very much.
Now, it's important to understand what one is not considering on this appeal. Section 2 is within Part 1 of the statute. If one turns back a page, one sees Part 1. Ordinary time limits for different classes of action. And then within Part 1, as I've said, we have actions founded on tort, Section 2. An action founded on tort shall not be brought after the expiration of 6 years from the date on which the cause of action accrued. As I'm sure the court is all too well aware, there are and will continue to be endless cases concerned with when the cause of action accrued in tort. But let us now turn, if we may, to section 14A of the Act. And that is in the authorities bundle, if you prefer, behind divider 1, or it's on page 2444 here in the white. Now, the heading to section 14A is special time limit for negligence actions where facts relevant to cause of action are not known at date of accrual. And of course, sections 14A and 14B were introduced, among other things, to tackle the difficulty caused by the case of Pirelli, where it was held that cracking had occurred unknown to the claimant, and his cause of action had been and gone before he was even aware of it. The first thing to observe about section 14A is section 14A2, which provides that section 2 of this Act, which we have just looked at, shall not apply to an action to which this section applies. In other words, we are not in the territory anymore of when did the cause of action in tort accrue. Now, I won't dwell on this section of the Act because the court will be familiar with it, but just on the way through, we recall from subsection 3 that an action to which this section applies shall not be brought after the expiration of the period in accordance with subsection 4. And subsection 4 refers either to the 6 years from the date on which the cause of action accrued, or 3 years from the starting date. And my lords and my lady will remember that the starting date is based upon, I'm looking now at subsection 5, second line, the earliest date on which the plaintiff or any person and so on and so forth had the knowledge and the right to bring an action. Subsection 6 goes on to explain a little bit more about what the knowledge means. Subsection 7 goes on to explain a little bit more about what the material facts are. Now, if we then turn on to section 14B, this is another time limit. So before I leave 14A, it's common ground that this case falls within 14A. We have pleaded a date of knowledge of, if I remember correctly, March 2019. No positive case is advanced for any earlier date of knowledge. Therefore, the proceedings were begun within the 3 years from that date, and we are simply put to proof that we did not have the relevant knowledge earlier than that date. So we are within section 14A, and we are in time under section 14A. So all that's left then is section 14B. And one must look at section 14B with some considerable care. It again is in the bundle, this time at divider 2, or in the white book 2447. Now, as I go through, may I emphasise certain words? So an action, and an action is the claimant's action, an action for damages for negligence, other than one to which Section 11 applies, shall not be brought after the expiration of 15 years from the date, or if more than one, the last of the dates, I emphasise the last of the dates, on which there occurred any act or omission, so we know that we're looking at acts or omissions, which is alleged to constitute negligence, to which the damage in respect to which damages are claimed, underlying claimed, is alleged to be attributable. And again, underlining alleged in both of those sentences. And one must not overlook subsection 2. This section bars the right of action in a case to which subsection 1 applies, notwithstanding A, that the cause of action has not yet accrued, and B, where the starting date has not yet occurred before the end of the period of limitation prescribed by this section. So, what is this period of limitation? It is a complex period of limitation drafted in bespoke fashion to cater for difficulties caused by the case of Pirelli in the House of Lords.
I don't think the 15 years is. The 15 years was 14A was drafted to deal with Pirelli to bring back knowledge, so that there was the point about having cracking that you didn't even know about because it was on the inside of a 200-foot chimney. But 14B was effectively the logical consequence of doing something about the cracking in the chimney you didn't know anything about, or what was said to be the logical consequence. But it's a slightly more indirect consequence of Pirelli, because it was thought, well, you can't be liable a generation down the line.
No.
So the 15 years comes in.
Your Lordship is entirely right.
And I mean, it's always called the long stop, whether that's accurate or not. I mean, that's how everybody always thinks of it. It's
Yes,
the long stop date.
First of all, your Lordship is right. Liability would be open-ended under 14A, so it had to stop somewhere, and this is the way it has stopped.
Yeah.
We are within 14A. 14B is the period of limitation that we are concerned with. And so when we ask ourselves, what is the test to be applied in relation to the application to disallow the amendment, it becomes quite a, if I can put it this way, quite a mouthful. So let me try and say what it is, and I hope the court won't mind, but I've taken the liberty of writing it down so that I can hand it up to the court as I make my submission.
So you're going to tell us what the limitation period.
I'm going to say what the test is
Oh, what?
for the purposes, because Section 35, Section 35.3 and Rule 17.4 only take us part of the way, because in each case they invite an inquiry into what is the limitation period that we are talking about. And we are talking about only one limitation period. We're not talking about the Section 2, the Limitation Act limitation period. We're not talking about Section 14A limitation period. We are talking about the limitation period in Section 14B. And so the way we put it is this. In the context of Section 14B, the question posed by Section 35.3 and Rule 17.4, namely, whether the new claim advanced by amendment is made after the expiry of a limitation period, is answered by determining whether the date, and here we come into the language of Section 14B, whether the date of the act or omission, 1, alleged to constitute negligence, 2, and to which the damage is alleged to be attributable, occurred within or outside the 15-year period. That is the test to be applied on this appeal. The consequence is set out, and this is a submission, paragraph 2, only if the date of the act or omission alleged to constitute negligence and to which the damage is alleged to be attributable occurred outside the 15-year period, shall the action not be brought by operation of the limitation period in in section 14B.
I thought you might be about to say, when you made the point that you have pleaded a starting point, that subsection 2B doesn't apply because that applies when the starting point has not yet occurred, whereas you say it has. I thought you might be about to say that the 15-year period doesn't apply in this case. You get 3 years from 2019 anyway, but you're not going there.
No, because, my lord, that's not how the...
Because it is an overriding 15
It is an overriding long stop, my lord, yes. And so, what are we not looking at, my lords and my lady? We are not looking at when the cause of action accrued. That's not on the table. We are not looking at when damage occurred. That's the same thing. Your cause of action accrues in tort when your damage occurs. And we're not looking at section 14A. And we accept entirely that there may well be debates in relation to section 2 about when a cause of action accrues, and the other side put in their evidence and they say, well, we think your damage occurred far earlier than you think, and therefore it's inappropriate for you to have amendments in your claim form. You must rely on a new claim form. We also agree that where the relevant limitation period is section 14A, there will be debates about the date of knowledge. So, for example, the defendant may say, well, you say you only found out in 2019, whereas it's pretty obvious from these emails that we've got, going back to 2016, that you knew earlier. Therefore, again, new claim form, please. You mustn't rely on amending without court permission. Now, in the present case, when we're looking at section 14B, where the claimant constrains his case to only acts or omissions which fall within the 15-year period, there can be no question of limitation. That is because all of the acts or omissions which are relied upon fall within the rule provided for by section 14B, and there are no drawings relied upon which fall outside the rule provided for by section 14B.
But they have to be alleged to be causative acts or omissions.
They do, and they are. And at trial, we will be either wrong about that or right about that.
Well, in due course, perhaps you'll show us where in your pleading there is the allegation that an act within the 15 years is causative.
Well, I'll come on to that, because that falls within the question of whether the claim was indeed constrained. If the claim was constrained to acts or omissions that fall only within the 15-year period, then the plea that the breaches, the negligent acts or omissions, cause the loss and damage is a plea which is already made in the particulars of
Well,
claim.
there are two separate things. One is whether you say in your pleading we're only claiming for acts or omissions after the 18th of March 2005, and the second is whether you plead that acts or omissions after that date caused the damage.
But my lord, if we constrained, we have pleaded causation and resulting in the loss and damage that has been claimed. Now, if this court finds, as the court below found, that we had indeed constrained our claim to acts or omissions which took place since the 18th of March 2005, and there are various other submissions to make about that in due course, but if that is the finding, then automatically the plea that is made is that acts or omissions are the acts or omissions after the 18th of March, and that they cause the loss and damage claimed. And at trial, there may well be issues about whether, for example, an element of the building had been constructed prior to one of those drawings, which was after the 18th of March, and that's a debate that will no doubt take place. But in the manner in which the claim has been limited, there is no universe in which a court at the end of trial says you would succeed on breach of duty and causation and loss, but your claim is time barred. That is, if we're right about the claim having been constrained, that is an impossible conclusion.
But if you're going to plead only acts after that date and say that they were causative, hasn't there got to be some factual basis for that in order for somebody to put their name to a statement of truth?
Well, yes, but at the moment, on the pleadings, if the court finds that the case is unconstrained, then although the intention was only to rely upon drawings after the 18th of March, it can be seen that there are early ones that should have been relied upon, then nevertheless they're all relied upon. And if there are fewer drawings that can be relied upon, the analysis is still the same. The analysis is your drawings ought to have reflected structural requirements that would ensure that the building was safe and had its relevant factor of safety and did not need evacuating in the way that Capital East did in this case. And that allegation is either made out on expert evidence in due course, or it's not. But it's not it isn't a fundamental challenge to the way in which the case is constrained. And it certainly isn't a challenge, my lord, that goes to the question of limitation. And I should also say this, and I'll come on to whether the claim was constrained in a moment, but at all times, and including dealing with the learned judge below, my client offered to have reflected in any order the constraint that was under discussion. So I don't know whether that helps your lordship in relation to this question.
Well, I think that's your answer to it.
My lord, so the second submission, the second part of my submission was how is the test to be applied? And we say that this is perfectly straightforward. The court looks at the claim, that the court identifies the acts or omissions alleged to constitute negligence and to which the damage is alleged to be attributable, and then calculates the 15 years. And we say that is it, neither more nor less. And the court does not ask itself whether the cause of action accrued earlier. This is because section 14b makes clear that that's not the inquiry. And nor does the court ask itself whether other acts or omissions not relied upon by the claimant suggest that the cause of action accrued earlier. Again, because accrual is not the inquiry, and second, because a claimant is entitled to constrain his claim. So in our submission then, applying the test, it is simply not arguable that the constrained claim is time barred.
You say arguable. You haven't dealt with, your test doesn't refer to arguability.
No, that is true. Your lordship is absolutely right.
Your test is a binary black and white, in or out. So I was going to ask you how you squared that with the Chandra case.
No, forgive me, it is an error. It should say that the test is applied on an arguability basis.
Right.
By determining whether it is arguable that the date.
So we could insert in your paragraph 2 only if it is reasonably arguable that. Is that where that would go?
Yes, correct, my lord. Please forgive the oversight. So the submission is this: it is simply not arguable that the constrained claim is time barred because none of the acts or omissions alleged to be negligent and to which the damage is alleged to be attributable occurred outside the 15 years. And in our submission, that is both the beginning and the end of the inquiry. And as I said a moment ago, if we're right that the claim is so constrained that there is no judgment in this action that holds the claim was time barred. It's not possible. And my lords, my lady, may I add this, that there is no trick, there is no device here. My client, Barrett Homes, Wilson Homes, a well-known house builder, was in the business of removing cladding from a building when it discovered, at its own expense, when it discovered these defects in other developments. That caused an investigation into numerous other developments, 130 or so, involving AECOM group engineers. And the upshot of that is a whole series of claims or potential claims. Some blatantly within time have been issued and are making progress in an ordinary way without limitation challenges. Other claims will never see the light of day. They're plainly and obviously time barred. They won't be brought, and Barrett will fix these developments at its own expense.
And that's on the application of the long stop, effectively.
Yeah.
I mean, so you've got, and we understand that, because of the detailed investigation into cladding, other things were found. So Pirelli-wise, other cracks in the chimney were found that otherwise wouldn't have been because the chimney's being investigated for something else. Understand that. Some fall the wrong side of the 15-year line, some fall the right side, and then some inevitably are going to be in the middle.
And here we are with a difficult one. Now, because of the bright clarity of Section 14B, unlike, sadly, Section 2, which relies on when did the damage occur untoward, fortunately, in Section 14B, we are blessed because all we have to look for are acts or omissions. And the law in relation to that, so far as at least construction developments are concerned, is reasonably well refined. And it is essentially accepted that when the inadequate structural work is built, incorporated into the building in reliance on the drawing, that is when, in effect, you have accrual of the cause of action under the ordinary test. But under the Section 14 test, we are only interested in the acts or omissions themselves. And so it's possible by refining the claim, by making it as granular as possible, even down to looking at the dates of revisions. And we have both my learned friend's table in the bundle and Mr. Adjetive's table in the bundle. One can see revision by revision what falls off the edge of the world if the amendment is disallowed, but what stays in the world, if I can put it that way, if the amendment is allowed to stand. And there could be considerable impacts. Now,
can I just pick up on something you just said, that under 14B you're only interested in acts or omissions. You're only interested in acts or omissions, but to which the damage in respect of which damages are claimed is alleged to be attributable.
yes.
So the Pearson education, whatever it was called, rose back in, doesn't it, there, because it's acts and omissions to which the damage alleged is attributable.
Yeah, well, my lord, it has to be to which the damage alleged is attributable. But in this case, it is the damage alleged.
Well, that's going back to the are the pleadings constrained point.
Yeah.
But just on the point of principle, we're not just interested in acts or omissions. It's got to be acts or omissions to which the damage claimed is attributable.
Yes, but one mustn't overlook the words alleged in 1A and 1B.
Yeah, well, that takes you to. I understand you say that takes you to the pleadings, but that's all we've got in one sense, because we're not in a case looking at facts.
No, exactly.
But the whether it's alleged or however it's put, the causative nature of the acts and omissions is not irrelevant.
Well, it's a question of focus. So, in this case, there isn't any debate or doubt about the fact that the negligent acts or omissions are alleged to have caused the damage which is claimed. That is certainly pleaded, and of course, in due course, there may need to be refinement and focus and experts' reports and all of the usual things that follow. Remember too that we are at a very early stage in this matter. We have only the particulars of claim. There's been no defence from Cameron Taylor because they relied on an arbitration clause, and so only served an acknowledgement of service.
Yeah.
Now, not in answer to your lordship's question, that's the first answer. The second answer is this. Yes, it certainly refers to the damage, but again, I repeat, we're not concerned with when the damage occurred. We are not concerned with when the damage occurred because we are not concerned with when the cause of action accrued. Section 2 does not apply. So,
I mean, to make this a bit more concrete, if we look at paragraph 47 of your pleading,
yes.
which is on page 121, at the moment, it says that the Feltham defects, and each of them, constituted and/or were the result of negligence by Kramer and Taylor. That's one statement.
Yes.
What you're saying is that that needs to be read as were the result of negligence by Kramer and Taylor committed after the 18th of March 2005.
Correct.
And that seems to me to be an entirely different statement. I simply don't know what is your foundation for being able to make that.
Well, it may be helpful if I go on to the question of whether the claim is constrained, because that may answer some of these.
Well, that was your next heading.
It was. But just before I do that, though, may I just finish the train of submission that I was originally on? As I said, some claims, a great many developments and unfortunately a great many issues arising. Some straightforward, no questions of limitation. Others, obviously time barred, not troubling the cause, will pay themselves. In the ones in the middle, please bear this in mind. It is of no interest on the part of BDW. It suits BDW not at all to rely on any acts or omissions prior to the 18th of March 2005. It can never serve BDW in an interlocutory stage. It can never serve BDW during the unfolding of the case with witness statements, expert reports and all the rest of it, and it cannot serve BDW at trial. And with that by way of introduction, and bearing in mind that my client simply wants, with all of the battles that it's fighting, to adopt a realistic approach, let me then turn to the question of whether the claim was constrained. Now, we've looked at the reply, which is at tab 6 of the supplemental bundle. And the reply was drafted in the light of URS Corporation, the other defence, saying, well, look, here are a load of detailed reasons why your claim is time, and not least the section 14b point. It's helpful as I go past, actually, just to show the colour. Now, I'll do that later. And so within the reply, as we've seen, there's a very carefully formulated plea at page 59 of the bundle. Page 59 of the bundle.
59.
59. Well, it should be 59 of the supplemental bundle.
Oh, sorry. Sorry, my fault. Yeah.
So BDW does not rely on any negligent act or omission which occurred more than 15 years before the date upon which BDW brought the claim, whether that is 6th or 18th of March, when the final amendment was filed, as having given rise to the damage claimed herein. And then further down the page, 5321, any drawings relied upon by BDW as having been negligent and having given rise to the damage alleged for each originally issued or issued revisions after 18th of March, the acts or omissions relied upon therefore occurred after the backstop date, if and insofar as there were revisions of the relevant drawings issued on or prior to the backstop date, BDW does not seek to rely upon the same in these proceedings. Now, I entirely accept that this was a reply to the URS defence, but it was intended by my clients and later made good. I'll explain why, that they intended the exact same plea to apply to the claim against Kramer and Taylor. What is the reason for them doing that? The answer is there is nothing in it for them whatsoever to rely on any drawings earlier, because they're just out on the very clear long stop of section 14b. There's no point relying on it. So next then is the evidence of Mr. Ajeti, and that is also in the supplemental bundle at tab 7a. And may I draw the court's attention to page 70, Mr. Adjuti's witness statement, and the heading, the drawings relied upon. Yeah. And this is the witness statement in response to the application to disallow the amendments, and that's this part of the appeal. And what he says at under that heading, the drawings relied upon by BDW as giving rise to the defects, as set out paragraph 2.63.24 of my first statement. The last amendment was made on the 18th of March. Given the time by which BDW became aware of the defects set out above, claims based on negligent acts or omissions which post-date 18th of March will therefore be in time. Okay, and implicit, those that don't wait. 4.7, accordingly, for the purposes of the particulars of claim, and this was Mr. Adjuti's evidence, for the purposes of the particulars of claim, BDW sought to identify the drawings issued by URS and or Cameron Taylor, which were related to each of the alleged defects, and the date on which those drawings were issued, and to pursue claims only insofar as relevant drawings were issued after the 18th of March. BDW has since confirmed that, insofar as drawings or drawing revisions relating to any given defect were also issued on or prior to the 18th of March, and in respect of which BDW might, but for the expiry of the statutory limitation period, have otherwise alleged negligence, BDW does not pursue any claim in reliance on such drawings. And admittedly, he refers to the reply, which is the reply to URS, but what one cannot overlook is his reference to Cameron Taylor in the second line, and the overall purpose that he describes of my client as it went about the rather hurried process of producing the particulars of claim on not a great deal of raw knowledge. Now,
But there's a difference, isn't there, between what he's saying here, which is effectively that, well, there might have been causative negligence before the relevant date, but we won't rely on it, and the case which you need to pursue, which is that the relevant negligence occurred after the date.
well, Lord, we don't...
This reads like a concession rather than facing up to what you have to prove.
But if the concession and the limitation of the claim is rightly made and rightly acknowledged to be made, well, then it is a matter for my client to make out its so limited case at trial. My lord, the end of the day at trial, the damage is that the building was constructed with designs both as to reinforcement, point loading, shear loading, and so on, that were not structurally sufficient for its purpose. Now, either there were negligent acts that gave rise to that loss after the 18th of March, or there were not. But where a claim is constrained to acts after the 18th of March 05, then it is not a claim that can be time-barred. And insofar as there is any deficiency of plea, my lord, respectfully, the outcome of this appeal ought not to turn on that. But any deficiency.
Well, I understand that, and usually that is right, but the whole case turns on the pleading. Sorry, the whole argument turns on the pleading.
Well, my lord, it does.
Because if you're right, you say this isn't anything to do with limitation at all.
Yeah.
And limitation would never need to be decided.
Correct.
And so that is potentially quite an unusual situation in relation to events that occurred 15 or more years ago, and therefore the structure, form, content of the pleading is important.
Well, it is, my lord. But may I say this, though, as another consideration which, in my submission, the court needs to weigh in the balance. It is early days. We are only looking at the particulars of claim. That there is a good deal of investigation yet to take place. This is a case in which the court, the Technology and Construction Court, is likely to order expert evidence from structural engineers. And those structural engineers will be tasked with examining the relevant drawings, examining.
Well, I don't think so, because if you're right and the claim isn't statute barred, if I was the case managing judge, I would order preliminary issues as to whether the drawings on which reliance was placed had any connection at all to the damage. And taking your point to its logical conclusion, that would be the next step. I certainly wouldn't be getting the parties to go to the expense of expert evidence in those circumstances.
Well, it's interesting. Your Lordship's intervention is timely. One of the submissions that I was going to go on to make was this, that we must divide up the various tools which the CPR provides for parties when dealing with cases that a defendant, for example, in this case, might regard as weak or difficult or beset with problems. Now, what we're dealing with here in our submission is a simple question of limitation. It is not a state trial, as my Lord Justice Coulson said yesterday in another context. Either the claim looking at section 14b as limited is time barred or it isn't, and then we get on. Now, that does not prevent my learned friend, if she thinks, well, the claim might not be time barred, but it's very weak because look at all of these earlier drawings, she can make applications to have issues summarily determined, or as my Lord has suggested, she can apply to have preliminary issues.
But all of that presupposes that you're right on the point you're currently addressing us on, namely that the claim is constrained.
Well, my Lord, can I continue with those submissions? So we've now looked at Mr. Adjeti's evidence. Before the judge below, we made clear, both in skeleton and in submissions, that the intention was to constrain the claim in relation to Kramer and Taylor as well. And we also made quite clear to the judge below that if he had concern about making that constraining of the claim formal, then we were perfectly content to have that reflected in the order. And may I remind the court that that proposal stands and is made again in our skeleton at, I think, paragraph 12, although it might be 14. Well, we make the exact same point. We can well understand that any court might think that ought to be made formal, but the judge below did not, because he was perfectly satisfied that we'd made clear that we were constraining the case. And in that respect, may I take the court to the judgment, which is divider 7 of the core bundle. And first, please, to paragraph 35, which is at page 65. So page 65, tab 7 of the core bundle. The judge says at paragraph 35, the claimant's case is that the claim in relation to Feltham Axiom is not arguably time barred because the claimant has restricted itself to the drawings issued after the 18th of March 2005, which is where any act or omission on their behalf, which could be alleged to constitute negligence, could arise. And then paragraph 43, please. Paragraph 43, the claimant's case is that the claim has been made in a time-limited way, so that it is not arguable that the claim is statute barred. That has been achieved by confining the claim to acts and omissions, thus adopting the words of the Limitation Act, which he then quotes, which occurred from 18th of March 2005 onwards. Therefore, the only drawings and revisions upon which the claimant can rely, for that is how the defendants acted or omitted to act, must relate to that 15-year period. And then similarly, paragraph 47, if you look 1, 2, 3, 4, 5, 6, 7 lines down, by confining his claim to that period, he is ensuring that it is brought within the limitation period. It is no answer to say that because there may have been some other act or omission which occurred before the 15-year period, which may be responsible for some of the damage alleged, the claim put forward, which is restricted to the 15-year period, is arguably time barred. And then finally in the judgment, paragraph 49, the effect of the way the claimant has put its case.
When this was litigated in front of Judge Kramer, was he taken through the point that we were taken through, which shows that it's only in the reply that it's a pleaded point that you've limited your claim in this way and it doesn't deal with the CTC aspect? Was he taken to the reply and shown that sequence?
I'm sure.
I couldn't find it anywhere in the judgment. That analysis.
The hearing took place over 2 days and a good deal of ground was covered. To the best of my recollection, he was taken to that.
Because the issue for us, surely, is whether he's right in reaching the conclusions that he does at 47 and 49. I mean, that's really the point on.
I'm coming on. Yes, I'm.
Because the ratio is really where he says he agrees with you.
Yeah.
Yes, but he agrees with me in the context of what by now is surely beyond any doubt that we are limiting our claim in the way that we say we're limiting our claim.
Well, we're here to see whether or not that's right. But that's the ratio of the case. In paragraphs 47 and 49, on both occasions, you say something and the judge agrees. Which I'm sure is very common, Mr. Hargreaves, in your professional
Very
career.
reassuring for you.
But that really is the ratio.
Well, at the risk of going further than perhaps I need to, could I also just quickly draw the court's attention to the reasons for refusing permission at divider 8 of the court. And really just to put it beyond any doubt even more, page 86 of the bundle, this is the core bundle tab 8.
Yeah.
So A, he refers to Chandra and Brook North, and then in the last few lines he says, because the claimant limited its claims to acts and emissions which occurred in more than 15 years. Similarly, last couple of lines of B, and similarly the last 4 lines of C. May I just read those? That is an illogical stance when faced with a claim which is limited to acts and omissions which occurred in the 15-year period. If the claimant fails to prove that it was these which caused the damage it loses, limitation defences do not come into consideration. Respectfully, we say that that is exactly right. Now,
it's a one-sentence response, and it's either right or wrong, but it's a one-sentence response. None of Ms. Parkin's points should get the defendant home, because this is a claim which, as pleaded, is restricted to matters within the last 15 years.
Well, admittedly not as pleaded, but as stated to the judge, as stated in reply, as stated in evidence. That is how the claim is constrained. A claimant is entitled to constrain his claim. If a court has any doubt that a claimant is constraining his claim, then the court can take the party's submission to that effect.
Well, you say admittedly not as pleaded. Are we going to are we going to look at the particulars of claim?
Well, we certainly can if we're desisting.
Because I mean, on the face of it, those aren't constrained.
I accept that. But the question at this stage of my submissions is, was nonetheless the claim constrained? In our respectful submission, it is clear that the claim was so constrained, and the judge found that the claim was so constrained. Now, in our submission, it would be wrong for this court to conclude that the judge was wrong to make that determination in circumstances where, first of all, there's evidence to show that BDW constrained its claim, both in the reply and from Mr. Adjety. Secondly, where the application below proceeded on the express basis that the claim was so limited. Thirdly, it was offered that the constraint be formally reflected in the order, as it still is. Fourthly, where it is self-evident that there's no point in BDW relying on drawings which are outside the 15-year period.
Well, we have to be slightly more rigorous than that, don't we? You say, well, there's no point, but if you've got a pleading such as the one we looked at yesterday in relation to Block I, which makes no reference to any drawing or drawing date at all, just by way of example, then that remains the pleaded case that the defendants have to meet. And so it's not entirely straightforward, is it, to say, well, that's a constrained claim and questions of limitation would never arise?
It may be that this court chooses to remit the case for a debate about amendments. It would be, in our respectful submission, unfortunate, with so much water under the bridge, and with BDW's intent to limit its case, both for commercial and practical reasons, plain and clear, it would be unfortunate in our submission if the appeal were determined upon that basis. Because as we saw from my learned friend Miss Parkin's table of drawings and their dates that my Lord Justice Mayles commented upon yesterday, one sees how many drawings fall off the table and would no longer be capable of being relied upon. And if the only point remaining against me is that the pleading might be, but currently has not yet been clarified, to take into account the effects of the constraining of the case, then, my lords and my lady, it seems to me that is a practical issue that can conveniently be dealt with by an amendment. It seems to me it wouldn't be right for the potentially serious financial consequences of having the amendment disallowed to be visited on my client in that sense.
Well, you say it can be dealt with by an amendment, and maybe it can, but is there any evidence before us that Mr. Kirkpatrick, or indeed anybody on your side, would be in a position to give a statement of truth that it was acts after the 18th of March which caused the damage?
Well,
I mean, I don't think Mr. Ajeti says that, and that's a rather gaping hole, because you're not, you say it can be dealt with by an amendment, but unless somebody is prepared to put their name to that with all the consequences, then you're not in a position to make that amendment.
no, well,
And that's why I drew the distinction between, as it were, the concession, we won't rely on these drawings, and the positive case you need to make.
the positive case that we need to make, my lord, is contained within the plea that is already advanced. All one is doing is taking out elements of the plea. One is not adding in anything new. And the question whether, in the end, it will be established that those drawings were causative of the loss is a matter that cannot be determined by solicitors or clients sitting there and thinking about it.
So
It can only
the
be determined
consequence of
by
that-
experts.
The consequence of that is that currently nobody on your side is in a position to give a statement of truth that the relevant negligent acts occurred after the cut-off date.
But my lord, in a case of this sort, in the Technology and Construction Court, leaving aside the situation that we find ourselves in today, the question is, does the solicitor or the client who signs that reasonably believe the case that's pleaded in the pleading? Now, at this stage, in this case, before even the defence has been seen to the case which is advanced, it is certainly the belief that these drawings, which provided for the reinforcement or the loadings or the limitations as to shear failure and so on, it is of course the understanding of the solicitor and the client that those drawings were causative of the loss, all of them. But in circumstances where some of the drawings must fall away, that does not alter the lay belief of the client or the solicitor that these losses resulted from the drawings that remain. And it will only be when the consulting engineers produce their reports, for they will have to look at what happened in consequence of each of the drawings and at what stage the various concrete elements were poured with the reinforcement within them and so on. Only they will be able to assist the court with whether or not these drawings caused the loss. And even then, my Lord Justice Coulson will certainly be familiar with this, they will disagree when it comes to trial, and so then it will only be the judge who determines that question, and we will find out the answer for the first time in the judgment. That is how these complex engineering disputes unfold. And so the answer to your Lordship's question is yes, I will certainly have a solicitor and a lay client who will say, albeit we are now relying on a lesser set, a subset of the drawings, nonetheless, all these drawings were negligent, and yes, we believe that these drawings caused the loss that we rely on. Now, so may I come on to parts 4 and 5, which I'll deal with, I hope, reasonably quickly. The first question is, number 4 was my submission as to why the appellant is incorrect, and I think it may already be becoming apparent to the court why we say that.
Well, it comes back to the point I put to you before. Really, it's if your solution is right, then none of it matters.
Yes.
So it's a question of whether your case on the constrained nature of the claimant's case, it's a question of whether that's right or not. If it is, you say limitation doesn't arise.
Yes.
And since Miss Parkin's submissions are all based on limitation, that's that.
Yes. But my Lord, I think, okay, I'll take it then much more shortly.
I mean, that isn't that right? I mean,
It is right.
That's the basic point. I'm sure there's colour you'd want to add, but that is the basic point between you.
My Lord sees it exactly. May I just add a little colour? I'll take it very quickly. If I can turn to my learned friend's skeleton, we can see where the inquiry in my respectful submission goes wrong. So if you look at my learned friend's skeleton, it's internal page 8, bundle page 22, starting at paragraph 25. So if we have paragraph 25, in circumstances in which, and so on, and then over the page 23, there is a paragraph unnumbered and alone in the middle of the page beginning the learned judge.
Yeah.
The learned judge should have concluded that CTC had a reasonably arguable case, that causes of action in tort in relation to Feltham had crystallised more than 15 years before March 2020 because the damage occurred before March 2005. Now, again, I've made my submissions in relation to what the test is. My Lord, it is not right to be asking when the damage occurred or when the cause of action crystallised. Paragraph 26B, four lines in, this is because the date of the last act of alleged negligence, ... is conceptually different from the date when BDW's cause of action against CTC had accrued. Again, that is not the inquiry. Paragraph C, fourth and fifth line, must involve an assessment of when the cause of action accrued. Well, it's not right. And then there's another mention of the cause of action in subparagraph E. And so there is a distinction, failure to draw the distinction, relevant distinction, between two different things. A limitation under Section 2, the Limitation Act on one hand, limitation under Section 14B on the other. And the other erroneous failure to identify the relevant distinction is between these two questions. First of all, whether it's arguable that the claim against Cameron Taylor is time barred on the one hand, and whether it's arguable that the claim made against Cameron Taylor will not in due course succeed as a matter of either liability or causation. So in those respects, in our submission, that is why the claimant, why the appellant is incorrect. And very briefly, if I may, just giving the court some references to the judgment. If we can pick it up, I can show you very, very swiftly how it is that the judge both applied the right test and arrived at the right conclusion.
We're on to your point 5 now, are we?
We are, my lord. Yes.
Yeah.
So, paragraph 28, the judge identifies Rule 17.4 and asks himself whether it was arguable in respect of the amendment that a period of limitation has applied, has passed, has expired, forgive me. At 32, he recognises that the question is whether the amendment adds a claim outside the limitation period or whether it's arguable. You see arguable in the second line. Likewise, 41, there's a blunder here, but what he means is, in the second line, whether it is arguable that the limitation period was not current when the re-amendment was made.
I would be the last person to criticise a first instance judge for missing out a not.
I said he didn't mean to.
I think that was that and getting the claimant and the defendant the wrong way round were two well-known features of my extempore judgment. Okay, so we add the word not.
So not goes in. So
Yeah,
in other words,
Yeah.
he's applied, he's identified the relevant test.
Yeah.
Not only that, 17.4 arguability and so on, but he also identified the relevant test for the purpose of section 14b. And we see this in paragraph 43, which I've already looked at, so that it could not be arguable. 47 we've already looked at. He essentially makes the same point.
Well, 43 is your case.
Yeah, and
As I
48.
say, the ratio is when he says, I agree.
Yes, well, 48, and then 48 is where he gives his example, and we say that the example also demonstrates that the judge is clear on the test that he's applying under section 14b. And just before I leave this section of my submissions then, nor, I should add, was he unaware of Cameron Taylor's case. At paragraph 23, he rightly points out, if I can draw attention to the third line, does mean that the events of this case are very much on the cusp of extended limitation period available under section 14b. And then he talks about pushing forward and pushing back. So he accepted in that sense the submission of the learned friend about.
But that wasn't in dispute, was it? Because
No, it wasn't.
your application, which you're just about to come on to in relation to substitution, presupposes, doesn't it, a relevant limitation period has come to an end?
No, that's different. So just addressing that now for convenience. That's because of the drawings that fell away after 18th of March, but before the application was determined. That's the difference there. So it's between March and...
But that strengthens the point that it's on the cusp.
No, certainly it does.
That was all. That was the only point I was saying.
Yes.
That as you say, drawings falling away as time goes on because of the 15 years.
Exactly.
Yeah.
Yes, I agree with you. And at 42, recognising the defendant say it is their argument is that the drawings straddle the commencement of the 15-year period, and the claimant is yet to prove that the damage which it claims it suffered is necessary to affect the cause of action was due to something which happened before or after the beginning of the 15-year period. So that was, as it were, my learned friend's case. So, my lord, the upshot, I think, by now is clear. I don't think I need to deliver myself of a summary, unless your lordships would, and my lady would like one. And if there are no questions, I can move now on to the other part of the.
No, we're fine on the first point. So then the substitution.
Yes.
And do you agree with Ms. Parkin that the first element of this is we're back to the same point?
Yes.
So if you're right about that, then the substitution's in play, and we go on to the second point. But if you're wrong, then that would deal with the substitution point.
I agree.
Fine, because that's very helpful. Because presumably that means your submissions are going to be on the 2 points that are taken in relation to mistake.
That's right.
Because Ms. Parkin does not challenge the exercise of discretion we got that far.
That's right.
Right.
Thank you. So far as the appeal in relation to the application to substitute is concerned, as I understood Malone and Friends submissions, Cameron Taylor originally ran 3 points. Number one, that Mr. Adjety made no mistake. Number two, that the mistake was as to identity, not name. And thirdly, absent the mistake, BDW could not show that one would have been named. Now, as I understood Malone and Friends submissions, I believe, but I'm not sure, that she restricts herself to the second and third of those points.
I think that was my understanding. Just give me those three. That was a neat summary. The first was Mr. Adjety made no mistake.
Yes.
What was the second?
The
and
second
third?
was that any mistake was as to identity, not name.
Yeah.
And thirdly, absent the mistake, can't show one. But let me just quickly deal with the first one in any case, so that there's no doubt. BDW's answer to that is set out in its skeleton at paragraph 26. The point is a narrow one. My lords, my lady, whatever the origin of the mistake, whatever the origin might be, the question is whether in the end the person responsible for issuing the claim form made a mistake. That's a question to be determined on the evidence. Mr. Adjety says he did make a mistake, and absent any serious challenge, that's the end of the matter. Certainly, and in any case here, there's no basis on which to say that the judge ought not to have made that determination. So on point one, that's really the end of it. So far as the second point is concerned, mistake as to identity not named. So far as this is concerned, there are difficult cases and there are straightforward cases. Let me give 3 examples of straightforward cases. And these are summarised conveniently in the judgment in Adelson. So in the case of Evans, the mistake was one of name because the writ was intended to be issued against the relevant landlord. The landlord was wrongly named as Charrington, when in fact the landlord was Bass. In Horn Roberts, the mistake was one of name because the writ was intended to be issued against the manufacturer of a particular vaccine batch, which was thought to have been Merck, but was in fact SmithKline. And finally, for these examples, in TRW, again, the mistake was one of name because the writ was intended to be issued in the name of the tenant of the 3rd floor. That was thought to have been TP ICAP PLC, but was in fact TP ICAP Group Services Limited. This too, in our submission, is an easy case. We have Mr. Adjety's evidence at paragraphs 3.27 to 3.29. I wonder if I could just direct the court very briefly again to that. This is in the supplemental bundle.
Yeah.
It's page 46, behind divider 5.
Yeah.
And if the court doesn't mind, let me just read all of the relevant evidence, starting at 3.20. So we have
to read. Tell us what you want us to read, and we'll read it.
Okay, 3.20
Yeah.
through to 3.24,
Okay.
and then 3.27 through to 3.29.
Yeah. The 3.27 is where it comes together, is it?
That's where it comes together.
But you want us to read the background.
Just the background, but it helps certainly in relation to the urgency, the way that information was flooding in in light of the investigation, something I've touched on before.
Yep.
Thank you. Well, applying the test to this evidence, it is in our submission obvious that the error was one as to name as opposed to identity. Mr. Ajeti thought that he was issuing proceedings against the party who was engaged to provide design services in respect of Feltham Axiom. He wrongly named that party as Cameron Taylor Consulting as opposed to Cameron Taylor 1. Not only was that finding open to the judge, but it was the obvious finding to make. There can, in our submission, be no plausible suggestion that the judge should have rejected that evidence. So far as the drawings which were available showing Cameron Taylor Bedford, in our respectful submission, that takes Cameron Taylor nowhere. The availability of those drawings is no different to the availability of the lease of the third floor in the TRW case. The fact remains, despite the availability of those drawings, that a mistake was made as to name. As for the suggestion that in fact Mr. Ajeti knew that CT1 was the right party, but decided instead to sue CT Consulting, there are several points. First, the suggestion is inherently unlikely. Secondly, no evidence was adduced by CT in support of the suggestion. Thirdly, no coherent reason was identified why Mr. Ajeti would do such a thing. Fourthly, the suggestion involves disbelieving Mr. Ajeti's evidence. And so, in conclusion, the judge was right to reject any such suggestion, and in our submission there's no conceivable basis upon which this court could find that the judge was wrong to do so. So that is the submission on mistake as to identity, not name. It's a mistake as to name. So then the third point, absent the mistake, BDW could not show that CT1 would have been named. In our submission, there are two important points which are key to this question. The first is a correct understanding of the words of Rule 19.53, which, if we may, we'll look at again in a moment. And second, to recognise that this question is very closely tied up with whether the error is one of name or identity. So starting with 19.53, if I may. It's important to recognise that the language of 19.53a doesn't just stop at the word mistake. So it says the addition or substitution of a party is necessary only if the court is satisfied that A, the new party is to be substituted for a party who was named in the claim form in mistake for the new party. And we say that most of the analysis simply flows from that language and that emphasis on the words for the new party. So the submission is this: where you have a genuine error of name and where you have a clear description of the party that you intend to sue, e.g. you intend to sue the person who provided the services, and then by mistake you name X rather than Y, then you satisfy the test without more. And on that approach, no inquiry is necessary as to whether the solicitor would have had access to material which would have enabled him to identify party Y as the defendant answering the legal description. It is enough that he identified and made clear the legal description. And we make this point in our skeleton at paragraphs 28.1 and 28.2, including, and I needn't turn it up, but including reference to the further information, remembering that further information was sought in respect of the claim form. In fact, I think we should turn that up because I don't think we've been to it. That's in the supplemental bundle. Does the court have the supplemental bundle divided too?
Yeah.
And the court will remember that the amendments were made in March. A notice was given early in April for service of the claim form because the defendants had been keeping an eye on claim forms in the court office, and this request for further information was dated the 14th of April and was responded to very shortly afterwards on the 20th of April. So question 2, against which of the defendants are the 2 new claims brought respectively? Answer, the claims in respect of the Freeman's Meadow development are brought against URS, and the claims in respect of Feltham Axiom are brought against Cameron Taylor Consulting. So it was made clear at the earliest stage that the intention was to sue the party in respect of the Feltham Axiom development, i.e. the engineer who provided services on it.
Yeah.
Now, so the submission is that in a straightforward case, such as this one and such as the others that I've mentioned, the outcome is inherent in the wording of the rules. No inquiry is needed as to whether you would have had the material to find the identity of party Y at the time. And can I make that good in the authorities? First of all, TRW, this is in Divider 9. It's really just a point of language. So Divider 9, paragraph 43. And if we start 4 lines down, or 5 lines down, had the mistake not been made, then TP ICAP Group would have been named as the second claimant, as the intention was for that party to the proceedings to be the company within the group that held the lease of the third floor. And we say respectfully that Mr. Justice Fraser there has the emphasis exactly right. That is the exact way that one should look at this test in a straightforward case. Similarly, the case Insight, which is behind Divider 7, this is Mr. Justice Leggett, as he then was, paragraph 52. And then 4 lines in here. It seems to me, however, that the only way in which the Sardinia Sources test is workable at all is to identify the relevant description of the intended claimant or defendant by reference to what description is material from a legal point of view to the claim made. And then over the page, 53, didn't read it all out, but from the 3rd line, a person who is an employer or a landlord or who owns property or cargo, so on and so forth, acquires by virtue of that role a set of legal rights and obligations which will generally be material to the claim made in the action. Thus, where the example is the defendant is sued for breach of a duty owed by reason of being the claimant's employer or landlord, then that will be the relevant description. And if the claimant turns out to have been mistaken in thinking that that person fitted the description, because the actual person was someone else, the mistake can be characterised as one's name. And then finally, 57. Where we've looked at this already, where the court can provide relief in case 1. Now, having made that submission, of course, there will not, one can't say that there won't be cases where the question of who you might have named is going to be relevant, because in the more difficult cases, that can take on a more important role. And Adelson is just one such case. But it is no good to be relying upon the facts of Adelson and saying that they are translatable into the present case.
Well, in Adelson, one of the difficulties, as I read the judgment, is that there was no evidence at all.
No evidence at
about
all.
the mistake.
Exactly.
So I think it was Mr. Justice Tugendhat at first instance effectively construed how the mistake might have arisen, and the court said that's not good enough.
Yeah, exactly right. That's exactly right. There are
So
other.
it's a strong case in that sense because there was no evidence at all.
No, correct. And other distinctions, I'll just mention them briefly. You'll remember that there was C2 and then hopefully by addition C3 and C4. But C2 had its own viable claim. So C2 was entitled to bring a claim in libel, just as were C3 and C4. So in other words, this wasn't a case where the party in relation to whom partial substitution was sought had no viable claim. And that you find in the judgment, paragraph 73. Another point of distinction is that in that case, it was certainly possible that a conscious decision had been made, both to name C2 and to describe it in the limited way in which it was described, and not to name as claimants C3 and C4. And all of those questions could only be answered but by evidence, and as my lord has pointed out, there was none. And so that is a case which is entirely distinguishable. So far as this submission is concerned, in our respectful submission, we say that this is not a case where there is any realistic reason to suppose that BDW would not have named CT1. This is an easy case, the description is clear, and the consequence follows from the rule. If I'm wrong about the consequence following from the rule, or if I'm wrong about it not being a realistic case, then the court is aware that we have an alternative case. The alternative case is that, in fact, Mr. Adjety did have access to material which would have enabled him to identify CT1 as the relevant party, namely the drawings that my learned friend relies upon, identifying Cameron Taylor Bedford, that being the previous name of CT1. And accompanying that submission is this one. There is no evidence or suggestion that there is any other Cameron Taylor company which would have been considered a relevant candidate as defendant instead of Cameron Taylor Consulting, other than Cameron Taylor 1 Limited. So in summary then, applying the relevant law to the question of mistake for 1953A, the position is as follows. Mr. Adjety made a mistake. He intended to amend the claim form to add the party that provided engineering services to BDW on Feltham. He understood it was consulting. It was not. This was his mistake. It was based on instructions, yes, but he still made a mistake for the purposes of the rule. Secondly, the error was one of name, not identity. He thought he was issuing proceedings against the party who was engaged as engineer, but he wrongly called that consulting instead of one. Thirdly, had the mistake not been made, Cameron Taylor 1 would have been named because they were the party that provided engineering services on Feltham Axiom. If necessary, he also had material before him on which he could have arrived at that determination. And so for those reasons, we invite the court to dismiss the appeal from the order for substitution, and for the reasons I've given earlier, we invite the court to dismiss the appeal from the order disallowing the amendment. So does the court have any questions?
Yeah, just one. Do you agree with Ms. Parkin that what we're concerned about for your substitution, that's under Rule 19, which would mean that we're not concerned. It was very muddly, I think, when they did the CPR and questions of adding parties got broken into two bits. But we're not concerned in this case, in this appeal, with 1743.
We are not.
You agree with that? Okay. you very much, Mr. Hargreaves. Yes, Miss Parkin, anything in reply?
My lords, my ladies, unless there's anything I can assist you with, I have no submissions to make in reply.
We don't have any questions for you. Thank you very much. Which concludes the hearing. Well, thank you both very much, and thank you to those sitting behind you for an extremely crisp series of submissions. We did tell you it wouldn't take a day and a half, so I'm very glad that we were right about that. Right, well, we will, as you can imagine, we will reserve our judgments. You will get those as soon as we can do them. You will understand that it is unlikely that you'll get them before the start of the vacation. But beyond that, I'm afraid I can't give any real indication of when you might get them. When you get them, they will be in draft. That's an opportunity for you to comment on the grammar, the spelling, but not an opportunity to re-argue the submissions. We would then expect the parties to be able to agree an order coming as a result of the judgments, and for that to be provided to us. In the unlikely event that you can't agree the consequential order, then we will consider very short submissions in writing and resolve any differences between you that way. It's almost certain that the hand down will be remote, but even if it isn't, there's no requirement for anybody to attend. All right, thank you both very much.
You can go get some shot.